Whether you have an employment, criminal, family, corporate, or personal injury matter, legal issues can be puzzling. The lawyers at Devry, Smith & Frank make all the pieces fit together.
I'm here to talk to you today about cause and terminations for cause. It is one of the most interesting, in my view, and befuddling areas of the law. It has lots of pitfalls, and it is something that is to be taken very seriously in terms of its handling. We're going to talk a little bit about it, some best practices, and we'll go through a couple of scenarios and deal with some of the recent cases that have come out in 2013. What is cause? Cause is a course of conduct by an employee which effectively amounts to a termination or a repudiation of the contract. And it will entitle an employer to end the contract with no reasonable notice obligations and call it a day. It is a very high threshold. The onus is on the employer, and some of the items that Megan and Flora talked about to you earlier today in the context of human rights and workplace regulations also apply to cause. You have to do your homework, and you have to try and meet that very high threshold that the courts will impose upon you. It's difficult. There are conflicting cases, and at the end of the day, if you haven't done your homework, you're going to bump into some problems. What is cause depends on very many factors, and it is a very fact-specific scenario, and it is very difficult from a lawyer's perspective to give advice about what constitutes cause and what does not. Unfortunately, the ramifications for getting it wrong are quite severe. We have a laundry list that is typically referred to as things that will entitle someone to be terminated for cause: theft, dishonesty, insubordination, those sorts of things. However, be careful. Just because it happens to fall within that category doesn't mean you should immediately jump to the conclusion that you have cause and that you should proceed. Again, do a thorough investigation, be unbiased, make sure that you target all of the witnesses, make sure that you document your investigation, and make sure that you come to a reasoned and proper conclusion before you jump to the next step of actually doing it. We would naturally recommend that you get some legal advice in this particular area. It's one of those things where you just never really know. There are cases out there in the world that say, yes, this guy stole from you and that's terrible, but he only did it once, so it's not cause. Yes, he was drinking at work, and yeah, I know you have a policy that says you're not supposed to drink at work, but yeah, that's not cause either. So it's very complicated. Weed versus Manitoba Court of Appeal, for anybody who wants to check out that case. Yes, I know he bought drugs from a guy in the cubicle next to him, and I know it's a bank, and that's not really something banks are in the business of, but no, that's not cause either. So, Soapwood Bank in Nova Scotia. So, you have to be very careful about the kind of thing. Once you make the decision to go ahead and do it, make sure that you do it properly in terms of the manner of the dismissal. I'm sure we're all aware of Wallace and UGG, which is a Supreme Court of Canada decision from a few years ago, which talks about being honest and candid and forthright in the manner of the dismissal, making sure that it's done right, because if you don't, it will attract additional damages and additional issues. Call a meeting. Don't do it in the middle of the workplace. Have it in a boardroom, have it somewhere private. Don't run up to the board and wipe their name off the chalkboard as being on the list of people working that day. That's happened. Don't go into the room alone. Have a witness. Make sure that you document what you have. Have a script. make sure that everybody knows what's going to be said. Deal with arrangements for packing up personal items and security and those sorts of things in a proper and subtle way, if I can put it that. Consider the time of day that you're going to do the termination. Consider the day of the week that you're going to do the termination. Be calm, be neutral as much as possible, and provide a letter. It shouldn't be a detailed letter, but it should set out why the termination is happening, what the grounds are, and at least then there will be a script, and there will be something that you can point to later to say, this is why we did it, and this is what was presented to the employee at the time. You want to make sure that you, as much as possible, make it a unilateral discussion. You don't want to engage in a bunch of he said, she said at that time. At that time, you've already done your investigation, you have a file, you have the evidence that you need, you've made the decision. There's no sense in engaging in the discussion at that juncture. Hopefully there's already been a discussion with the employee, the investigation has covered off his evidence, so that's not the time to collect the evidence. That's the time to get the job done and get it done as cleanly as you can. If all else fails, we recommend this poster. So try to. You're fired, but just look at this baby seal. It helps, just try to. It just goes back to the point that it's an emotional thing. You have to be neutral. You have to be calm, and you try to do it. Often you will get advice about trying to have the employee resign rather than terminating them for cause. And that's great. If you can get that to accomplish, then that does take care of a lot of subsequent lawsuits and things like that. However, be careful. Don't try to extract a resignation. Don't sort of extort or threaten various things in exchange for the resignation. You want the employee to voluntarily resign after having been faced with the situation, if at all possible. But again, there are a lot of pitfalls with that, as we're going to find out as we go forward today. So be careful. Some scenarios. So Gord has been an accountant for D&D for 10 years. Gord has a fabulous boss by the name of Mr. B. He comes to you as the HR manager and says that there are a number of discrepancies in the financial statements that Gord has been involved in preparing, and he thinks that Gord is money laundering. Mr. B also wants you to call the police, and he's worried about the clients finding out about all this and not being seen as having taken this matter seriously. So just by a show of hands, what should the HR manager do at that point? Should we terminate for cause? Yes? Who says yes? Unanimously no? Wow. Very good. Should we call the police? Who says yes? Unanimously no. Very good. Now, in this particular case, it actually happened, and the Court of Appeal came out with a decision in November relating to it. It's Pate Estate versus Galloway, Cavendish, and Harvey Townships. So in November, the Court of Appeal released its decision, and it really, for those of you who would like to copy the case or would like the link, I'm happy to get that for you. Just send me an email, and I'm happy to get that. This should be read by everyone as the what not to do case. It is something that I think is very instructive in a number of different ways. Mr. Pate was a building inspector with the township, and the manager uncovered a number of discrepancies in respect of building permits, and in particular building permit fees. There were fees that were collected in respect of various inspections and properties that were unaccounted for, and the assumption or decision at the time was that Mr. Pate was somehow involved in keeping those fees for himself. Mr. Pate did explain the discrepancies, although he was given virtually no particulars as to what it was that was alleged against him. And he was told that he could resign or he was terminated for cause. Unfortunately, he was also told that if he didn't resign, he would be reported to the police. And that was something that the court later found to be along the lines of the extortion that I was talking about earlier. Mr. Pate wasn't prepared to resign, and in fact, he was terminated for cause. He was terminated for cause in March of 1999, so it took almost 14 years to have this litigation ultimately work its way through to the conclusion of the Court of Appeal in November. But the court found that the manager also listened to his boss and elected to hand over the information that he had to the police. It was found that the township employer had exerted pressure on the investigating officers by calling OPP superiors and things like that, and eventually managed to convince the police to lay charges against Mr. Pate. There was a 4-day criminal trial that took place, but eventually in December of 2002, Mr. Pate was acquitted of the charges. Obviously, with the media attention in the particular local area, Mr. Pate found it impossible to find a new job, and eventually he sued for wrongful dismissal after his acquittal. So in December of 2013, he sued for wrongful dismissal, bad faith in the manner of the termination, aggravated damages for the distress that he'd been caused, and punitive damages and malicious prosecution. The trial judge finally, in December of 2009, made a finding, and he found that the township did not have cause to terminate Mr. Pate, and most damningly found that the township had conducted a very, very poor investigation, and in fact some of the bias and those sorts of things that Megan and Flora mentioned earlier came to the forefront. It turned out that the manager in this particular case was so excited and keen on getting a criminal conviction in order to protect the employer from the ultimate civil liability that he knowingly withheld evidence. He failed to hire any sort of outside independent help to conduct the investigation. Mr. Pate had a journal which he kept that tracked all of his daily activities. That found its way into the hands of the employer. The employer neglected to disclose that to either the investigating officers or to the court. The manager did it sounds like a very terrible, terrible job at cross-examination on the stand, had no explanations for why he did these things. Some of the files which would have explained some of the discrepancies had apparently been lost by the township in a move of offices. They neglected to mention that, and in fact suppressed that information in the course of the trial. And I think maybe most worse, I don't know, but there was also a finding by an internal committee of the city that in certain of the properties, Mr. Pate was ultimately exonerated completely of any wrongdoing. That evidence was also suppressed by the employer. And so if you take nothing else from today, learn that the investigating and all of the things that Megan and Flora set out for you earlier today, although in the context of human rights cases, that also applies to cause sorts of things and cause cases where you need to, as the employer, meet that high threshold of evidence. Being keen doesn't help you, though, if you're doing it inappropriately. The court, unfortunately for Mr. Pate, he died in June of 2001, just on the eve of the trial decision. It ultimately was appealed to the Court of Appeal. The Court of Appeal ordered a retrial on certain issues. 2 retrials happened without Mr. Pate's involvement, obviously, and eventually was appealed. Those 2 decisions were eventually appealed to the Court of Appeal, and we get the Court of Appeal's decision finally in November of 2013. The Court of Appeal upholds the malicious prosecution and the punitive damages awards, upholds the trial court's original decision in terms of the wrongful dismissal and the other heads of damages, so that Mr. Pate, in the end, although didn't get to see it, was awarded $75,000 in wrongful dismissal, which was effectively agreed to by the parties. In the course of the litigation, I guess eventually the employer decided that yes, maybe there was a wrongful dismissal, and they agreed on that number. Mr. Pate got $25,000 for 4 months' pay for the bad faith manner of the dismissal. So, attempting to extract resignations and things like that, threatening to report him to the police if he didn't resign, all came back to bite the employer. He was awarded $75,000 for aggravated damages for the mental distress that was caused to him, having been put through all of this, and the mental distress item is an important one. He got $1 for malicious prosecution, and again, effectively that was agreed to by the parties. Ultimately, the second trial decision was related to that, and it eventually said that yes, there was a malicious prosecution in this matter, and $1 would be the appropriate number. The big one, $450,000 in punitive damages was awarded against the township, which is a reduction by the Court of Appeal from the original $550,000 awarded at the trial, but nonetheless $450,000 in punitive damages against a township which really I don't think had the money to afford that. But in any event, the court in awarding that punitive damages award relied pretty heavily on a previous case known as McNeil. It's an excellent decision in that it does review the entire history almost of punitive damages awards in employment cases, so it's an interesting case to read from that perspective. And the cases are interesting in that they tend to be in the range of $25,000 to $100,000 or that range by and large, but there are these few cases where the court has really gone out of its way to say this is the kind of conduct that employers ought not to be engaged in, and this is the kind of conduct that we are going to penalize. The McNeil case that was relied on heavily by the Court of Appeal was a relatively similar case in that the employer in that case had video evidence of an employee stealing some items from its place of business, and they disclosed that and relied very heavily on that. Unfortunately, they also had video evidence of him putting it back, and they forgot to put forward that video evidence. So again, being complete and thorough and unbiased in your investigations is a very, very important thing to do. Second scenario, Mr. Bobo has been working for a company for 23 years. He's the top sales guy and everybody likes him. He takes a top client out for lunch. He also takes the company car without being authorized to do so specifically, although he has, over the course of his employment history, taken the car from time to time. The lunch turns into a very, very liquid lunch. And on the way back, he gets involved in a serious accident. Company car is destroyed. he suffers life-threatening injuries, and he's fired for cause. He sues for 24 months of wrongful dismissal damages, and he wants to know what you guys think. Is that cause? Show of hands, yes, no? Okay. What if I told you that Bobo had never had a single incident like this in his entire 23-year history before that? Would it change anybody's mind? Nobody's? Okay. What if I said that there was absolutely no investigation conducted by the employer at all? Would that change anybody's mind? Who thinks that the employer can still claim cause? Yes? Yes, everybody says, everybody's not answering, nobody knows? Okay. What if I told you the employer had no code of conduct, had no written policies, had nothing like that to preclude this kind of activity? Everybody? Still the same? All right. What about jobs that involve drinking? And in fact, he's expected to entertain clients. He's expected to be drunk during the course of his employment. There is case law like that. That's absolutely what happens. The cases absolutely say it. That's something that's within the expectations. It's a different scenario, right? Ask Mr. Weeb, who in the Manitoba Court of Appeal decision with Central Transport was actually drinking at work, was intoxicated at work, and the court said, yeah, that's not cause. Sorry. Anybody? No? Okay. Well, the case that I'm not even going to try to pronounce, Mr. D versus Lighting Dimensions, Inc., is a Superior Court decision 2012. Mr. D drove drunk after lunch. He had 4 beers in an hour. He did take the company car on that day without authorization, and he had a serious accident with life-threatening injuries. He broke his neck. He crashed on the 400. He was trying hard to get to Weber's to have a good hamburger. Didn't quite make it. He ended up at a different restaurant and instead had 4 beers at lunch and crashed his car. Fortunately or unfortunately, in a single car accident on the 400. He had 23 years of service. He had been that day visiting a client. The fact scenario is a little bit more favorable for the employer in that he was alone at lunch and decided that 4 beers at lunch alone was a good idea. He ended up being airlifted to the hospital. The blood sample was taken at the hospital. It was found to be in excess of legal limits, and he was charged. He pled guilty, and he ultimately was terminated for cause 1 month later by letter from the employer. The case notes that the employer really did not do any investigation at all. The employer relied on the, I guess, prima facie evidence that was coming forward in the criminal case, although the case at that point had not been resolved and he had not pled guilty. Mr. D persisted in his view that notwithstanding the criminal convictions that he wasn't drunk and he had been driving and he was just fine, and he in fact persisted in that position throughout the course of the trial. The court found that there was cause, and they relied upon, not the drinking and not those sorts of things, more upon the serious misconduct and the fact that the behavior of the employee wasn't trifling. It was impugned behavior that really could have constituted prejudice to the employer's business. It was inconsistent with implied terms of the employment agreement. And in this particular case, and I think one of the very helpful points for the employer was that the misconduct was in breach of an express provision of an employment agreement. So they did have a handbook. It did preclude drinking while at work, and the court relied upon that. The trial judge found serious misconduct that drunk driving is not just being intoxicated at work, because of course those cases were before the judge in terms of the fact that you can drink at work in certain cases and it may not be cause. The court relied upon the fact that it was damage to the employer's property, and that property had been taken without authority. And the court relied obviously on the criminal conviction, which is compelling, albeit not always determinative. In certain cases, there are acquittals on the criminal proceedings, and yet cause continues to be found at the civil level because it is a different test. Obviously, criminal test is much higher. So the trial judge relied on the handbook and the prejudicial aspects. The trial judge said that the employer could have been found liable had this not been a single car accident, and certainly the employer's clients would have thought less of the employer for not controlling its employees properly. As I said, Mr. D resisted in taking responsibility at the trial and continued to persist in his position that he wasn't drunk. So all of those things worked against him, and it was in fact held to be cause.